The Honorable the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, 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 all persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
It gets a bit tedious to write and say Supreme Court of the United States over and over, so people abbreviate this to SCOTUS. SCOTUS sort of sounds like a part of the male anatomy, which is brilliantly appropriate. Why? Just last Friday, June 26, 2015, the court told us this, quote, "The 14th Amendment requires a state to license a marriage between two people of the same sex and to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state," end quote. That's Tony Kennedy writing for the majority in Obergefell v. Hodges. I'm not exactly clear where the 14th Amendment orders the states to wed sodomites. It must be in the amendment's penumbras and emanations. The Christ-hating liberal Democrats around the land are rejoicing, saying that SCOTUS has made sodomy the law of the land. Apparently, we only have one branch of government because the Republicans are saying the same thing. Marco Rubio, a weasel-eyed rhino from Florida, stated the following in a press release on Friday. Quote, "While I disagree with this decision, we live in a republic and must abide by the law," end quote. That's found on rubio.senate.gov. I guess Rubio must be the Spanish word for eunuch. Since our quote leadership is telling us that we rednecks need to be good boys and girls and play along with SCOTUS's ruling on sodomy, perhaps we should find out what SCOTUS's jurisprudence actually is on sodomy. To the dismay of whatever homos may be listening, SCOTUS's sodomy jurisprudence is all over the map. In 1986, a lawyer for the aptly named Michael Hardwick argued in front of SCOTUS that Hardwick had a right to engage in consensual sodomy. The anti-sodomy laws of Georgia be damned. SCOTUS ruled in favor of Georgia and against Hardwick. The case is named Bowers v. Hardwick if you want to look up the details. That decision proves rather nettlesome when we fast forward to 2002 and look at a case called Lawrence and Garner v. Texas. In this case, the Supremes reversed themselves on Bowers v. Hardwick and said absolutely you have a right to engage in consensual sodomy. The most egregious flip-flop was Sandra Day O'Connor, who had ruled against Hardwick, but now ruled in favor of Lawrence and Garner. That's just SCOTUS's flip-flopping on one issue. To the amusement of all watching, SCOTUS goes flip-floppity-fly on a whole range of issues. We'll confine ourselves to just three: property rights, free speech, and religious dissent. Tell me if you can figure out what the court's jurisprudence is on private property. Fletcher v. Peck, 1810. The property rights of private citizens trump the property rights of the state government. Charles River Bridge v. Warren Bridge, 1837. Flip-floppity-fly, the property rights of the state government trump the property rights of private citizens. Kelo v. City of New London, 2005. This takes Charles River Bridge a step further. Not only do the property rights of the state trump those of citizens, but a state can also use its eminent domain authority to seize private property to sell to private developers. Now tell me if you can figure out what the court's jurisprudence is on free speech. R.A.V. versus St. Paul, 1992. SCOTUS voted 9-0, 9-0, that no ordinance may single out one type of speech as more blameworthy than another. Virginia v. Black, 2003, flip-floppity-fly, SCOTUS issued an incredibly confusing 7-2 decision, stating that an ordinance may indeed single out one type of speech as more blameworthy than another. Now tell me if you can figure out what the court's jurisprudence is on religious dissent, which is supposed to be protected by the First Amendment. Minersville School District v. Gobitis, 1940. SCOTUS ruled 8-1 that all school children must render a Nazi-style salute to the American flag. That includes Jehovah's Witness school children who object to flag saluting as idolatry. West Virginia State Board of Education v. Barnett, 1943. Flip-floppity fly, SCOTUS ruled 6-3 that forcing school children to render a Nazi-style salute to the American flag is unconstitutional. The appalling truth is that SCOTUS can't get its story straight on anything. Plessy v. Ferguson, 1896, reversed by Loving v. Virginia, 1967. Adkins v. Children's Hospital, 1923, reversed by West Coast Hotel Company v. Parrish, 1937. Jones v. City of Opelika, 1942, reversed by Murdoch v. Pennsylvania, 1943. Sherbert v. Verner, 1963, reversed by Employment Division v. Smith, 1988. Planned Parenthood of Missouri v. Danforth, 1976, reversed by Planned Parenthood Association v. Ashcroft, 1983. So I've got a question for you libbies. Is this the branch of government that you want making our laws? Is this the infallible oracle you're always telling us about? What does the Constitution say about this infallible oracle notion? Article 1 of the Constitution begins, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." Article 2 of the Constitution begins, "The executive power shall be vested in a President of the United States of America." Article 3 of the Constitution begins, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." Thus, as far as my limited redneck intellect can discern, the framers divided power between three separate but equal branches. But as noted at the top of the show, our betters among the Republican intelligentsia, I'm referring to castrati like Marco Rubio, gleefully join with the Democrats in informing us that this is not the case. What actually prevails is judicial supremacy. Popular referenda, state statutes, all of this is worthless. The ruling class just allows us hoi polloi to vote in order to make us feel good. Our votes actually mean nothing. In reality, this country is ruled by one man, Anthony Kennedy. This tendency to legislate from the bench began very early in the court's existence. In Marbury v. Madison, 1803, SCOTUS under John Marshall voted itself the right of judicial review, which is nowhere in Article 3 of the Constitution. Somebody should have nipped that overweening arrogance in the bud. Unfortunately, no one did. And by the time we get to Gregg v. Georgia, 1976, we have silly William Brenning declaring, quote, "This court inescapably has the duty, as the ultimate arbiter of the meaning of the Constitution, to say whether moral concepts require us to hold that the death penalty is cruel and unusual." End quote. Welcome to judicial tyranny. If you want to prevail over this judicial tyranny, then do not do what I see a number of Christians doing. I caught Franklin Graham on Fox News last night, and he sounded utterly pathetic and despairing. What kind of leadership is that? Are you going to follow him into battle? Can you imagine Walter Martin rolling over like that? Some of the rank and file seem despairing too. I dropped in at a Free Will Baptist church and spoke with a gentleman named Tom. He told me he's 74 years old, he has one foot in the grave and the other on a banana peel, and he's very glad for that. He just wants to die and not have to face what we're going to face. Fortunately, there are some Christian leaders who've still got backbones. I've never been a big Mike Huckabee supporter, but he is great on the traditional marriage issue. Here's what it reads on his campaign website. Quote, "I may stand alone, but I am absolutely faithful to the issue of marriage. Not because it's politically expedient, but because it's the biblical position the historical position, and the right position. We must defend, protect, and preserve traditional marriage." End quote. Not surprisingly, the very best voice on this issue is Ted Cruz. I call him St. Ted. Not only does St. Ted vocally defend traditional marriage, but he also proposes countermeasures against the tyranny that threatens marriage. St. Ted penned a brilliant op-ed in National Review Online, dated 6/26/15. May I read you some abstracts therefrom? The framers of our Constitution, despite their foresight and wisdom, did not anticipate judicial tyranny on this scale. Ellipses. The framers underestimated the justices' craving for legislative power, and they overestimated the Congress's backbone to curb it. It was clear even before the end of the founding era that the threat of impeachment was, in Thomas Jefferson's words, quote, "not even a scarecrow," end quote, to the justices. Today, the remedy of impeachment, the only one provided under our Constitution to cure judicial tyranny, is still no remedy at all. A Senate that cannot muster 51 votes to block an Attorney General nominee openly committed to continue an unprecedented course of executive branch lawlessness can hardly be expected to muster the 67 votes needed to impeach an Anthony Kennedy. ... In order to provide the people themselves with a constitutional remedy to the problem of judicial activism and the means for throwing off judicial tyrants, I am proposing an amendment to the United States Constitution that would subject the justices of the Supreme Court to periodic judicial retention elections. Every justice, beginning with the second national election after his or her appointment, will answer to the American people and the states in a retention election every 8 years. Those justices deemed unfit for retention by both a majority of the American people as a whole and by majorities of the electorates in at least half of the 50 states, will be removed from office and disqualified from future service on the court. Can I have a hallelujah? I would take St. Ted a step further. I would actually prorogue the SCOTUS until Congress and the voting public shall have decided how properly to rein it in. Additionally, we may want to take a lesson from Louisiana. Whereas the other 49 states use English common law, which basically amounts to judge-made law, Louisiana uses Napoleonic code law. If we had a written code, then these overweening judges wouldn't be able to fiddle around with our republic. As I end this recording, I want to remind you of Isaiah 54:17. "No weapon that is formed against thee shall prosper, and every tongue that shall rise against thee in judgment thou shalt condemn. This is the heritage of the servants of the Lord, and their righteousness is of me, saith the Lord." Do you hear that? Their judgments and their weapons shall fall before the righteous. The Almighty has promised it, and his word shall not return unto him void. Isaiah 55:11. Keep up the fight, and I'll see you next time.
This is the end of the message. For further information regarding other topics available on audio recording and in printed form, visit us online at orthorev.net.